board games, online curriculum and actual experience. In today's course you will learn what is the Uniform Commercial Code, what is intellectual property, what are contracts, and what are torts. This information will be presented to you by means of whiteboard animation and screencast videos. After viewing this video, if you have any questions about the content, questions about the course, or would like to know how you can make the Young Entrepreneur Program available to your school or organization, please contact us at contact@bayscholars.org.
The Uniform Commercial Code is a set of suggestions that have been adopted by many states and enacted into their laws. This means that the UCC holds great power and authority over your day-to-day business activities. The UCC consists of 9 articles that focuses on sales, leases, negotiable instruments, bank deposits and collections, funds transfer, letters of credit, bulk sales, documents of title, investment securities, and secure transactions. Each article is very important to understand as you grow your business. However, for purposes of this course, we will focus on Article 2 of the UCC, which is sales. There are 7 parts to Article 2. Part 1 is the short title, General Construction and Subject Matter. Part 2 is Form, Formation, and Readjustment of Contract. Part 3 is General Obligation and Construction of Contract. Part 4 is Title, Creditor, and Good Faith Purchases. Part 5 is Performance. Part 6 is Breach, Repudiation, and Excuse. And Part 7 is Remedies. Let's get a basic understanding of these parts. Part 1 is where you will find vocabulary and the definitions of terms that are very important to know before and during conducting business. Terms such as merchant, goods, contract, agreement, and termination will be defined here with definitions that may be similar in a regular dictionary. So it's important to understand what is meant by these terms so that you will be acting in accordance with all the laws that govern business. We will discuss contracts in the next lesson. However, let us see what the definition of merchant is. Merchant means a person who deals in goods of the kind or otherwise by his occupation holds himself out as having knowledge or skill peculiar to the practices or goods involved in a transaction, or to whom such knowledge or skill may be attributed by his employment of an agent or broker or other intermediary who by his occupation holds himself out as having such knowledge or skill. That's a very long definition, right? And if you noticed, another important vocabulary word, goods, was mentioned in the definition. You don't have to remember this definition now, but you do have to remember that these laws can be long and tedious. However, this is the price of doing business. Parts 2 and 3 deal with contract formation and general obligations. As previously mentioned, we will discuss contracts in the next lesson. You will learn the elements that make up a contract and the requirements of the parties involved. Part 4 deals with the purchasing of goods on good faith and the transferring of goods. Good faith is a standard of measurement that buyers and sellers must meet when interacting with one another. Part 5 deals with many scenarios that can and will exist between a buyer and seller, a merchant and consumer. Part 6 deals with issues when one party does not uphold their part of the agreement. And Part 7 is the remedy for when someone does not uphold their part of the agreement. As you can already tell, the UCC is a long set of complex laws that need to be understood carefully. It is not find these articles when you are uncertain about a business activity or practice. As we wrap up this lesson, let's consider the following questions. What does UCC stand for? What article deals with sales? Since as an entrepreneur you will be providing a good or a service, you will definitely have to be familiar with intellectual property. Intellectual property is the product of human ingenuity protected by law. To make it plain and simple, intellectual property is the result of what someone is thinking. Whatever you think about is intellectual property. However, not everything you think about is protected by law. This becomes very important as you learn about copyrights, trademarks, patents, and trade secrets. Intellectual property is protected in the Constitution. However, the Constitution only addressed copyrights and patents. Other laws were enacted to include trademarks and trade secrets. Whether your intellectual property is protected in the form of copyright, patent, trademark, or trade secret, it will only be protected for a limited time. A patent grants property rights to the investor for a specified period of time. A utility patent and a plant patent expire 20 years following the original patent application. A design patent expires 14 years afterward. These are the only types of patents that exist. A owner of a patent is called a patentee. A utility patent is the most common type of patent awarded for inventions or improvements to methods, processes, machinery, and compositions of matter. A plant patent is a unique patent right granted to investors of new forms of plants. A design patent is a unique patent right granted to protect the look, not functionality, of an invention. A patent confers or gives you the right to exclude others from making, using, or selling the patented product. This is consistent with the copyright clause of the United States Constitution, which grants investors the exclusive right to their discoveries. Trade secrets are secret information that companies have about their goods and/or services. Some examples of trade secrets are soft drink recipes, KFC's 11 spices, and Big Mac's special sauce. Trade secrets can theoretically last forever. That is, it can last forever if the owner of the secret can actually keep it a secret. Trade secrets are unlike patents in an important way. With a patent, the inventor must specifically disclose the details of the invention when applying for a patent. This means that the inventor has not protected the secret of the invention. However, in exchange for this disclosure, a patent owner has a legal monopoly over the property for a specified period of time. So even if others discover the secret of the invention, not a difficult task since patent applications are public record, they are prohibited from making, using, or selling it without the patentee's permission. After the patent expires, then the patentee no longer has a property right to exclude others. A trademark is any kind of name, logo, motto, device, sound, color, or look that identifies the origin of a particular good or service. Trademarks only exist if a consumer identifies it with a particular origin. For example, Diet Coke has been identified by the consumer as a carbonated drink from the Coca-Cola Company. On the other hand, Diet Cola can be associated with any company, so it would not be recognized as a trademark. Existing trademarks can lose their protection if the mark is no longer considered unique by the consumer. That is, if they can no longer associate it with a specific company. If a trademark is being used for a business that provides services, the trademark will be officially recognized as a service mark. Facebook is an example of a service mark. Copyright is the exclusive right of authors to their respective works, to the exclusion of others. Copyright is designed to protect creativity. Copyright extends to any form of creative expression, including digital forms. A work must be original, not copied, and fixed in a durable medium to be copyrighted. A durable medium is a tangible way the information is presented. Copyright work is automatically copyrighted upon its creation. However, it is further protected when such creation is registered with the Copyright Office. Copyright protection lasts for 70 years after the death of the author. Examples of works protected under copyright law include literary works, musical works, dramatic works, motion picture and other audiovisual works, and sound recordings. As we wrap up this lesson, consider the following questions. What is intellectual property? What two forms of intellectual property are protected by the U.S. Constitution?
Cleaning service. Can I ask you a couple of questions? Can you clean my garage? Can you steam my carpets? Can you work really fast? Do you provide your own cleaning supplies? Can you work around my schedule? Do you screen your workers? Can you clean my business too? Okay, I don't need my husband anymore.
Contract is the most important concept to understand as an entrepreneur. The concept of contracts existed way before the creation of humans. This is why you will learn that there are laws that govern contracts, not laws that create them. Contract law is the most important law of all laws created because no interaction can exist without the formation of some type of contract. The study of contracts and contract law can be quite complex. However, in this course you will learn the basics such as formation and requirements. Contract law as it pertains to your business will derive from two different authorities, common law and the Uniform Commercial Code. In the previous lesson we've learned that Article 2 of the UCC covers contract formation. Common law and the UCC will differ when it comes to formation and requirements of contractual obligations. In this lesson, we will focus on common law understanding. So, what is a contract? Technically, a contract is nothing more than an agreement between two or more parties. But for the law's sake, we will add a little more to that definition. According to the law, a contract is a legally enforceable promise. In order for a contract to be considered formed, these basic elements must be met. There must be an offer, there must be an acceptance, and there must be mutual consideration. In addition, the contract must be for a legal purpose, and the parties must have capacity to enter the contract. So of course there must be a promisor and there must be a promisee. The offer is made by the offerer or the promisor, and it must communicate something specific to the offeree or promisee. Here's an example of an offer. The offerer says to the offeree, "I offer to sell you my scooter for $400. The acceptance must be a mirror image of the offer, meaning that it must be precisely the same as the offer. For example, the offeree says to the offerer, "I agreed to buy a scooter for $400. Consideration is a bargain for exchange. So, using the previous examples, the bargain for exchange is the scooter for $400. This example, offer and acceptance, is actually legal, so this would be legally enforceable. However, if the offerer offered to sell an obviously stolen computer for $400, then this promise will not be legally enforceable even if the offeree accepts. Capacity is the legal ability to enter into a legal contract. For example, if the offerer offers to sell his scooter for $400 and the offeree accepts and pays for the scooter, the contract may be unenforceable because the offeree was 8 years old and not legally allowed to enter into this particular contract. As a young entrepreneur, you will be presented with many contractual opportunities. As a minor, some offers you will be allowed to accept, others you cannot. On the other hand, as a minor, you are allowed to make offers that others can accept. Contracts can be formed orally or they can be written. There are many contracts that you will have to be familiar with depending on the details of the formation. For example, if both parties make a promise, then the contract is considered bilateral. If only one party makes a promise, then the contract is considered unilateral. Understanding contracts is the most important part of entrepreneurship. If there is a breach or violation of contract, then the breaching party may be held liable for damages and other remedies for failure to perform. This will bring us to another important concept you must understand as the entrepreneur: litigation. America is known for its litigious practices. This means that the courts are filled with people suing other people or businesses. We will learn a little more about litigation in the next lesson. As we wrap up this lesson, consider the following questions. What is a contract? What are the elements that make up a contract? A tort can be broadly defined as a civil wrong other than breach of contract. In other words, a tort is any legal, recognizable injury arising from the conduct or non-conduct, because in some cases, failing to act may be a tort, of persons or corporations. There are several key differences between torts and contracts. First is the realm of possible plaintiffs. As mentioned in the previous lesson, litigation is a huge concern for entrepreneurs. If someone decides to sue you or your business, that person is known as the plaintiff. You or your business will be known as the defendant. In contract law, only persons that you have a contract with or you are a third-party beneficiary to can possibly sue you for breach of contract. In tort law, just about anyone can sue you as long as they can establish that you owe them some sort of legally recognizable duty. The second key difference is damages or remedies. In contract law, damages are not difficult to calculate, as contract law seeks to place the parties in the same position as if the bargain had been performed. This is known as compensatory damages. The plaintiff is being compensated for the breach. In tort law, unlike contract law, the plaintiff can also receive punitive damages, which are money damages awarded to punish the defendant for gross negligence and to deter future wrongdoing. Tort law is a reflection of American societal values. Each tort case arises out of different factual situations, and a jury of peers is asked to decide whether or not the tortfeasor, the person committed the tort, has violated a societal norm. Torts can be broadly categorized into three categories, depending on the level of intent demonstrated by the tortfeasor. These categories are intentional tort, negligence, strict liability. In an intentional tort, the tortfeasor intends the consequences of his or her act or knew with assault, battery, and misappropriation are examples of intentional torts. Assault is an intentional, unexcused act that creates in another person a reasonable apprehension or fear of immediate harm or offensive contact. Battery is the completed assault. Battery is the physical contact. Misappropriation takes place when a person or company uses someone else's name, likeness, or other identifying characteristics without permission. If the tortfeasor didn't act intentionally but nonetheless failed to act in the way a reasonable person would have acted, then negligence has taken place. To prove negligence, plaintiff has to demonstrate four elements are present. First, they have to establish that the defendant owed a duty to the plaintiff. Second, the plaintiff has to demonstrate that the defendant breached that duty. Third, the plaintiff has to prove that the defendant's conduct caused the injury. Finally, the plaintiff has to demonstrate legally recognizable injuries. How these elements are applied are specific to each case and the current laws that address similar situations. An important concept of negligence to be familiar with as an entrepreneur is malpractice. This type of negligence, known as professional negligence, is committed by certain professionals such as doctors, accountants, dentists, architects, and lawyers. Strict liability torts require neither intent nor carelessness. In fact, if strict liability applies, it is irrelevant how carelessly or how carefully the defendant acted. It doesn't matter if the defendant took every precaution to avoid harm. If someone is harmed in a situation where strict liability applies, then the defendant is liable. Since this rule can have harsh consequences, it applies only in a few limited circumstances. If you plan to open up a restaurant, bar, or tavern, be mindful that strict liability will apply if alcohol is served to a minor or visibly intoxicated persons. As we wrap up this lesson, consider the following questions. What is a tort? The person who is suing your business is known as the what?